Hey everybody, TacticAngel here, and I've got some serious opinions about dessert. We're talking about cake, people, and it's not just any cake. It's a Supreme Court kind of cake. If you don't know what I'm talking about, this is all about the Masterpiece Cake Shop versus the Colorado Civil Rights Commission. A brief history. Before we start talking about this, I'd like to get a few things out of the way. Number one, this should never be happening. As a basic rule of life, I highly encourage you never to mess with people who handle your food. If you want a cake, and somebody doesn't want to bake you that cake, then you don't want that cake that they make for you, because you're either going to get a shitty cake or an actual shit cake. Let me put it this way. If you're going to throw an extravagantly expensive party, you don't want one of the centerpieces to be a really terrible cake. Secondly, I know some of you are wondering, who the hell is going to take a bakery dispute to the Supreme Court? I thought that, and the answer are these two fellows, Charlie Craig and David Mullins. They're just regular people, I guess, but I bet this guy is a pretentious jerk. Why do I think that? Well, the dark-on-dark power-clashing outfit, the stern chin above the little people, and the hair. In other words, he kind of reminds me of myself. I did, after all, just spend an hour animating my own hair, so I think I know about this stuff. Also, it seems to me that only a pretentious asshole would get so tied up in knots about pastry that he takes the baker to court and then the Supreme Court. So it's kind of a self-fulfilling definition. I imagine at some point somebody said, like a whole lot of other things that have just gone too far, it's the principle of it. I've said it, you've said it, but whenever we say something like this, what we all kind of know we're saying is, I realize this has gone too far, but at this point, I dug this hole for no reason, so now I just need to make sure it's somebody's grave. So long story short, this shouldn't be happening, because there are two more probable and more acceptable uses of everyone's time. These dudes go hire somebody else to bake them a cake, or the cake guy fucks it up and takes their money anyway. Problem solved. And that said, I'm pretty happy that neither of these parties have had the good sense to take the obvious way out, because now we can get into the actual history. David Mullins and Charlie Craig met in 2010 at a party. They fell in love and have been together ever since. About a year after meeting, they talked to each other about getting married. So they started looking for people to host the reception, florists, and all the other nonsense associated with getting married, one of which is obviously a cake. So they approached Jack Phillips, the owner, chief designer, and baker at Masterpiece Cake Shop. They said they wanted a custom wedding cake. He asked, for whom? They said for us. But then he said he couldn't do that. Though, according to the Supreme Court, he was willing to create other custom cakes, cupcakes, or provide any other services his business offers for any other type of event. Now, a curious thing about this is that at the time that this occurred, gay marriage was illegal in the state of Colorado. It would not become legal until October of 2014. If you went to the state of Colorado requesting a marriage license, you would have been denied. If you, say, wanted to get married in Massachusetts and asked the state of Colorado to recognize your marriage, they would have told you to fuck off. You couldn't even have had a civil union in a place like Illinois and had that recognized by Colorado. I don't want to move too far ahead of this because getting married in Massachusetts was exactly what they intended to do, and then to come back to Colorado just to be two ordinary people who just were completely unrelated to one another. This is also illustrative of why I've said this has gone too far. Because they did exactly this thing in 2012, so they've been fighting about this fucking cake for 5 years. Eventually, you just gotta let it go. Back to the cake, though. In 2012, if you wanted a cake to celebrate an event that is not legal in Colorado, you better make that cake. Why? In 2008, Colorado's governor signed into law SB 08-200, which added sexual orientation to the list of things protected by civil rights legislation in Colorado. The bill functionally makes Mr. Phillips legally required to provide any service to Mr. Mullins and Mr. Craig that he would provide to any other person absent their sexual orientation. Earlier versions of Mr. Phillips' complaints include a reference to the fact that this was not a legal ceremony that would be happening, and in part, his objection may have been based on this fact. But it is clear that his major issue is that he thinks that marriage is between a man and a woman. Now, there is a thing in law that is usually called legal purpose. And what that means, in short, is that only lawful contracts are binding. And if any small part of Mr. Phillips thought that these two gentlemen were involving him in a conspiracy to commit some sort of crime, then he should have an out right there. Now, I don't think this is particularly interesting as an argument, and I don't really think that it's the case for Mr. Phillips. It's certainly not what was argued in front of the Supreme Court. What is being argued is whether or not Mr. Phillips has a right, as an owner of a business, to refuse to make a custom piece of art that expresses an opinion that is contrary to his own, because his creation of that cake may in some way imply that he endorses the message. The First Amendment provides Americans with the freedom of speech, but the Supreme Court has also long held that this also includes the right not to speak. The government cannot force anyone to say anything or create a piece of art that expresses an opinion that is not his own. The argument for Mr. Phillips is essentially that he does not wish to appear to support gay marriage when, in fact, he does not. Would it be reasonable to think that he endorses this simply by means of him baking a cake for the wedding? I think particularly today, yes, absolutely. If you look at YouTube and the adpocalypse debacle, it started because people complained that certain ads were running before certain content. 1 minute you're watching an Apple commercial for some shit you'll never need, and the next you're watching an ISIS recruiting video or child porn or whatever. Does that mean that Apple supports ISIS or the exploitation of children? I don't think so. I don't think a reasonable person thinks that. I think a reasonable person understands that these companies pay Google to place a certain number of ads in front of a semi-random collection of videos. But there are clearly enough unreasonable people to change the ad buying habits and policies of a large number of companies, both large and small. As a business owner, I may not want to be associated with that, whether or not I agree with the policy. Do you suppose it would have been better to charge a different rate? Let's say, as an artisan, I ask to be named on the wedding program. It's free advertisement for me, and I figure I get maybe 2 or 3 referrals for every cake that I make. If the state forces me to make this cake, but I want to be completely anonymous, it seems like a reasonable accommodation. Maybe I even go so far as to write up a non-disclosure agreement. It would seem a little bit paranoid, but at least I would have a legal recourse if somebody advertised that I was making their cake. But this NDA is an additional expense to me. Would it be reasonable then for me to charge you more for that cake? I would think so, since it covers an identifiable expense. But could I also charge for a loss of revenue? In cake terms, an average cake costs about $500 for a wedding, which is just nuts. But apparently the number's in the $480 range right about now. If I charge one couple that amount, $500, and then I charge $500 for a cake plus my loss of future revenue, which is about, let's say, $300 per cake I won't sell, plus $100 for the NDA, could I charge the second couple $1,350? I think the answer is probably not, and that's probably an emotional answer, not a logical one. In other circumstances, I could charge for expenses. There's going to obviously be some argument about whether they're reasonable expenses, but we shouldn't pretend that all of the expenses that we have today are reasonable. Let's go a little bit deeper into that idea. Let's say that rather than talking about cakes, we have a guy named Hiro Masamune. He's a Japanese immigrant who fell in love with American-style sandwiches, and he comes to America, he opens a sandwich shop, and he calls it Hiro's Heroes. Let's say somebody wants Hiro to cater their picnic, and for the sake of argument, they're a white nationalist or a black nationalist. Take your pick. Now, some of you say, TacticAngel, that's totally different. I'd agree to a certain extent, but chances are pretty good that Hiro would cater to an Independence Day party. In fact, for the sake of argument, let's say that Hiro even caters an annual America Fuck Yeah party and an Ass Kickers of America party, which is hosted by several veterans and put on annually to celebrate the greatness of America. Because Hiro is a good American who loves his country, it's hard to say that he has a problem with nationalism. His problem is with the whiteness of this guy's nationalism or with the blackness of this other guy's nationalism. Whether true or not, the argument can be made that his issue is with the racial bit. And race is a protected class, just like, in Colorado, sexual orientation. Maybe he could even be forced into catering this very public, very unpopular event. Now, because of sandwich proximity and the transitive property of sandwich creation means to the idiots who started the adpocalypse on YouTube that Hiro is a racist, probably a sexist, xenophobic, etc. person. He's bad. Hiro will inevitably lose business because of this. Shouldn't he have the right to refuse this job or to charge a higher price? Now, I think most of us would say that Hiro should be able to reject this contract outright. And I think if he was compelled, most of us would say that he has a bona fide interest in his anonymity and should be reasonably compensated for any additional expenses and any loss of future earnings he might incur. Whether or not you believe in any one of these particular causes, there are definitely areas of the United States where gay marriage is substantially unpopular. The law rarely and should never force people to martyr themselves or their livelihood for someone else's cause. This would be an appropriate time to mention that the Colorado Civil Rights Commission has ruled several times in favor of organizations that reject business on the grounds that the work was personally offensive, so long as the rationale was not religious in motivation. I will repeat that because it does bear repeating. The Colorado Civil Rights Tribunal accepts a company's right to reject business so long as it is for reasons other than a constitutionally protected right. Indeed, this action even earned them some reprimand from the court for behavior that might indicate prejudice on the grounds of religious preference by the Civil Rights Commission, and religious preference is one of the very things the CCRC is supposed to protect. What this basically means is if George Washington's descendants want a banner celebrating the father of our country, the greatest man ever, something to that effect, if the sign shop owner doesn't want to print that message for any reason, according to the CCRC, as long as that reason isn't religious, then he should not have to. Perhaps the sign shop owner objects to some of George Washington's personal views. Maybe he is the descendant of slaves. Maybe he even thinks wrongly that he is the descendant of slaves. Maybe he just doesn't like some guy he used to know 30 years ago in high school who was named Washington too. It doesn't matter. His rationale doesn't have to be good. He just has to think it's personally offensive. And I agree with that. I certainly wouldn't fault a Cherokee baker for refusing to bake a cake celebrating Andrew Jackson. That has nothing to do with race or religion. If you can reject making a cake on any grounds, whether those grounds are completely rational or entirely irrational, then it seems like you ought to be able to reject to make a cake because of a constitutionally protected right. That isn't how the state sees it, though. In the argument before the justices, Colorado argued that an atheist couple could hire a religious person to write wedding vows that specifically mocked or denigrated his own religious beliefs. I'm not joking. I listened to the whole thing. I will put the time marker in the description. That's just crazy, though. What business is it of the state to compel what is essentially a speechwriter to renounce his own God? And how does that square with the Constitution? This is actually where I think Justice Ginsburg didn't quite get it, or wasn't paying attention when it was read into the record, or maybe fell asleep. The state is requiring that Masterpiece Cake Shop offer any service that they would make available to anyone else absent their sexual orientation. This includes writing on the cake. This would be essentially, if I were the owner, they would be able to come in and ask me to write whatever they wanted, signed TacticAngel. Just put the TacticAngel thing at the end, and it sure looks like I endorse that. Further, the state also ordered that Mr. Phillips provide remedial training to his employees to explain why his religion was bad. That is, of course, why the First Amendment says, Congress shall make no law respecting the establishment of religion, or prohibiting the free exercise thereof, as long as you admit to everyone that your beliefs are bullshit. Wait, no, it doesn't say that. As a minor point, some people are going to get a little hung up on whether a company can claim a religious objection, because companies don't believe in anything. They can't. They're just a piece of paper. Well, I'm not going to say that any law is settled science. There's plenty of reason to believe that the court isn't real interested in this question, especially so recently after addressing part of this question in a much larger case. It's also not the most interesting part of this question because this isn't a massive corporation. It's quite literally a mom and pop shop. So identifying the religious preference of the company is not particularly difficult. But since we're talking about everything else, why don't we just go down this rabbit hole just a little bit more? If this was a big company and Mr. Phillips was the CEO rather than basically being the company himself, and he was just a businessman who only ran the company, who had no talents to actually affect its operation other than, books and whatever else goes into a business that I clearly don't understand. So he has a branch that's run by Joe Everyman. Joe is a devout man of any particular religion. Pick one, it doesn't matter. Craig and Mullins come in, and rather than the sole proprietors, the guy who owns the business, it is the employee that refuses. Mr. Phillips has no other baker qualified and no other branches within a reasonable distance. What does he do? Firing Joe will almost certainly provoke a lawsuit. Also, clearly some people think that failure to make a cake is lawsuit worthy. If you don't think he will be sued by his former employee, the ex-baker, and after firing him would be without his key employee, basically making him unable to make any cakes for a short time, then let me share with you some recent cases out there. A woman fired for saying it's okay to vote against same-sex marriage was fired and is suing. A Pentecostal woman is suing after being fired for wearing a denim skirt, and you can almost guarantee that it was floor length, rather than the required denim pants, without ever having worked a shift in this restaurant. A nurse sues after having her religious accommodation to not teach about birth control removed. This one was settled out of court, but that means that the company had to pay her money to make it go away. A bus driver wins her case after she was fired for refusing to have her fingerprints taken as part of a required background check because it would leave the mark of the devil on her and preclude her entry into heaven. She won that case. And this isn't just any bus, this was a school bus. The state has a bona fide interest in making sure she's not some crazy person or some escaped convict. If you don't think that Joe Everyman, the baker, isn't going to sue his boss for firing him over religious grounds, then you don't understand how the world works. So back to Mr. Phillips, the hypothetical businessman. What does he do? Is he just fucked? It's an honest question. I'm not sure that I know, because it doesn't seem like he should automatically suffer a fine, and it doesn't seem like he should automatically have to walk into an expensive lawsuit. Moving on, that doesn't have anything to do with this. It's just a hypothetical so that we can think about how all of this stuff interacts, because that would be a pretty tricky question. And I don't think it would be Supreme Court worthy, but I have a feeling that Mr. Phillips wouldn't have done very well in that lawsuit either. Moving on, the state's argument is predicated on the Masterpiece Cake Shop being a place of public accommodation. We're going to touch a little bit on what public accommodation is. Mr. Phillips runs a business that is open to the public, therefore is a public business. He doesn't make cakes on an invite-only basis. There's no secret knock to make the front door open, and there's no roided-up bouncer keeping the riffraff out. As such, any service that he provides must be provided to all people who come into his shop on a non-discriminatory basis. If you give a service to one group of people, then you have to do it for everyone. It sounds nice and fair until we look back at Hero serving sandwiches to Nazis. But wait a minute, public buildings, by that I mean government buildings, are a place of public accommodation. Are we to believe that at the time when this cake shit was going on, that there was not one building in which a couple could apply for a marriage license? If a heterosexual couple could get such a license, then why couldn't these two guys? Shouldn't the Civil Rights Commission have ruled also against the state? And shouldn't the state then have to provide remedial training to all of its employees so that all of them know that Colorado's laws are dumb? Same-sex marriage was not legal at the time of this transaction. However, the applicable Colorado anti-discrimination law was. It was already in effect, and I think that the answer to that question is pretty obvious. So this is not a stretch of the imagination. While I would hold that being a sculptor is a more difficult profession, and that traditional sculpting, like that from marble, would typically be a more worthy artistic endeavor, what these two fellows are doing is hiring this man to create sketches, sculpt, and hand paint a cake that celebrates a view of marriage that is in conflict to his own. You do wonder if this had been a 57-year-old man marrying a conspicuously pregnant 14-year-old, which is acceptable in some cultures and religions, if the court would have had a similar lack of sympathy for Mr. Phillips' religious convictions, and in a way, his discrimination against an alternate culture or an alternate religion. Where I differ in the view of both Masterpiece Cake Shop and the Supreme Court here is that both the court and the defendant agree that they ought to provide that ready-made cake to somebody. If you listen to the arguments, the justices are keenly concerned that accepting that there is some amount of artistic expression involved in baking a cake might be the same as ordering someone into compelled speech, particularly when the state of Colorado has ordered that the cake maker must write whatever the couple wants on it. It does make me wonder what their opinion of a cake maker would be if they refused to write something like "Death to Americans" on a cake, if they might be a little bit more sympathetic. On the other hand, I wonder if they would also be more sympathetic of a cake maker who refuses to draw a picture of Muhammad on a cake. I imagine that that would be particularly offensive to a Muslim cake baker. I imagine a secular cake baker would also find it disrespectful. And indeed I do. And I imagine many more would simply not want to do it to avoid all of the anger and the inevitable death threats. Needless to say, there was a lot of apparent mental contortion involved in questioning whether or not a cake baker is an artist, and, like any other artist, if that art is considered speech. The court also tried to wrestle with the idea of gay rights versus the other historic prohibitions against interreligious or interracial marriage. Even Susan Wagoner, who represents Masterpiece, struggled quite a bit to try to come up with some sort of consistent logic that would apply in all cases, and in a way that we would all find not morally objectionable today. A rather shocking assertion by the Colorado Civil Rights Commission is the unlimited authority of a state to bar any sort of selection process for where charities can provide their services. Indeed, they practically accused Christians of not trying to help people who were not specifically Christian, even though there's almost no indication that such a thing happens. You walk into a food bank, very rarely do you have to tell what God you serve in order to get some food. The commission also had a weak argument because they argue that it is okay for someone to reject a request because they think something is personally offensive on grounds other than religion, but it is not okay to reject a request because you think something is personally offensive on religious grounds, as we have stated. What I didn't go into is that the actual definition of a place of public accommodation means any place offering services, facilities, privileges, advantages, or accommodations to the public, including but not limited to any business offering wholesale or retail sales to the public, any place to eat, drink, sleep, or rest, or any combination thereof, or any public building, park, arena, theater, hall, auditorium, museum, etc., 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 nonsense. However, a place of public accommodation shall not include a church, synagogue, mosque, or other place that is principally used for religious purposes. This is another fine example of the freedom of religion being codified in United States law, but the Civil Rights Tribunal ignoring that. In fact, the tribunal has acted in a manner that is inconsistent with Colorado's own constitution. Now, I'm not trying to skirt the issue. We are going to come back to the issue of public accommodation now and probably later again. A lot of the pushback that Mr. Phillips' lawyers are putting up is that Masterpiece Cake Shop would sell any baked item they had available in the store. All the cakes that Mr. Phillips creates otherwise, essentially, are custom ordered or commissioned. Mr. Phillips has rejected, for presumably a multitude of reasons, dozens of other requests for cake. The reasons for this weren't outlined in the actual court case. Perhaps they are for reasons other than a constitutionally protected right. I want to talk a little bit about this because I actually don't think this point should matter at all. There are places that you can go today and buy statues. These are statues you can put on your lawn to show you and all your neighbors that you have more money than you know what to do with. Some of these stores are run by artists themselves, and others are run by ordinary business people. So take one of these stores that perhaps specializes in statues of important historical figures. In this store, we have a statue of Martin Luther King Jr. As a public business, Mr. Mullins, Mr. Craig, and Mr. Phillips all agree he would be required to sell this item to anyone. It's a ready-made good. It's essentially sitting on a shelf, even though it's a statue and way too big. So he should have to provide that to anyone because that is an area of public accommodation. If Hero wants to come in and buy a copy of this statue because Martin Luther King Jr. was an inspirational figure and he considered him a great personal hero, he in fact is going to include the statue next to several other great people in history that Heroes honors outside their shop because they're really tripling down on this hero stuff. Great, that's exactly why art exists. But then maybe we have our guy from another particular club walk in. He wants to buy another copy of it because you can basically make tons of bronze statues out of one mold. He has some other opinions of Martin Luther King, and he intends to hang it from a tree. Can he buy it? Yeah, no, fuck no. Now you will notice that I haven't mentioned whether or not this particular store is owned by Joe Everyman or if it's the artist's personal store. And the truth is that in Colorado, it wouldn't really matter. There were two arguments sort of related to this made before the Supreme Court. One had to do with the transformative nature of the context on the piece. Justice Alito noted that selling the same cake labeled Best Day in History to a couple celebrating their anniversary on November 9th is much different than selling that exact cake with that exact message to someone celebrating Kristallnacht. If you are unfamiliar with what Kristallnacht is, it is the night that a whole bunch of pro-National Socialist German Workers' Party members went out and destroyed Jewish businesses by basically chucking rocks and other things through the glass, the crystal, at night. Crystal knocked. Terrible day in history. They also argued whether an African American sculptor could be compelled to erect a custom cross for one of these people. By public accommodation, the owner of that statue store is required to sell Martin Luther King to be lynched, and the sculptor may or may not be compelled under penalty of fine or jail to create a custom piece of work that would realistically depict his own lynching. I find it deeply troubling that the state thinks that it has any business in this. I don't care if it's just a person who owns the shop, but I feel particularly bad for any artist or artisan who's forced by the state to create art with a prescribed message. This is literally exactly what happened in the Soviet Union. If you want to listen to the whole argument, I would encourage you to do so. It is just under an hour and a half long. I can't help but get the impression that everybody is dancing around something that they don't want to out and out say. How do we undo this thing that is clearly fucked up without undoing every piece of civil rights legislation that we've ever written? Now we're going to take a little bit of a detour. In 2010, Rand Paul was campaigning for the Senate. In an interview, he was tossed what you could describe as a softball question for any other candidate. What do you think of the Civil Rights Act? In a way, only Rand Paul would be asked this question because Senator Paul is a very smart man, but his convictions outweigh his intellect, and he's a very smart guy. I don't actually remember what he said. It was really that he said anything other than what you would expect from the average politician. Something like, the Civil Rights Law of 1964 is one of the greatest pieces of legislation in history. Instead, what he said was some brainy nonsense, and it took more than 10 seconds to say, which meant that he was going to get crucified over it. And he did, but he still won. To put it plainly, the Civil Rights Act is a bill with 11 parts. And if you come from a libertarian point of view, you're usually okay with 9 or 10 of them. To put it simply, the cake case that we have here stumbles directly into the middle of a conundrum. There is nothing in the Constitution that allows the government to tell you who you must associate with, which includes business dealings. I believe the symptom is a result that we, as Americans, generally see our government as an instrument of good, or through the force of law we will create some sort of better society. And one of the great triumphs of that perception is the Civil Rights Act. This case perhaps is one of the better stages for this question because, as outlined above, what we are asking Mr. Phillips to do here is simply unnecessary and frivolous. I did a Google search, and there are over 20 bakeries within 10 miles of Masterpiece Cake Shop. In fact, it looks like there are at least 2 within a mile of this shop. Mr. Craig and Mr. Mullins don't live in a cake desert. That brings us really to our next point. I said we'd come back to the area of public accommodation. At some point, Justice Sotomayor remarks that there are places where people may not be able to find another baker or another florist. I would ask the listener to try to think back to a time in their life or to try to find some other memorable moment, even from hearsay, from your friends, from your family, of a tragic moment that centers around the absence of a cake or a really artful floral arrangement. Oh, my dad died, but if there had been a cake, just looking long and hard at history, I can find maybe one person who puts such high regard on cake, and that's Marie Antoinette. And her cake-centered universe came to sort of an abrupt and bloody end. So we're coming back to public accommodation. This is usually the sort of bane of libertarian thought on this subject. But the general principle of a free and liberal society is that you can do whatever you want until it actually harms someone else. Not hurts their feelings, but actually inflicts some sort of bodily harm, property damage, loss of time, loss of wages, something like that. While having a very liberal mindset, there are things that I do not think people should be able to do. I do not think that doctors should be able to refuse necessary medical procedures. And I think the proper application of the Hippocratic Oath requires that anyway. And I do not think that someone should have to suffer bodily injury or undue property loss due to someone's prejudice. TacticAngel, what the hell are you talking about? Well, I'm glad I asked myself for you that thing for me to keep this video going. If I'm driving through Arizona on a warm July summer day and I run out of gas, I don't think someone should be able to deny me food, shelter, or goods and services I require to extricate myself from this situation. If it's not obvious why I think this situation is different from potentially the life-altering event of not eating cake on a particular day from a particular bakery, that's because in one instance, I stand a pretty good chance of dying, and in the other, I might have to go somewhere else or just deal with it. In short, cake is not a human right. It should be mentioned that arguing the validity of civil rights laws in some way is pointless. You can point to practices that it has helped to end, and you can never compare it to the world that might have been without it. You don't know if it will be better or worse. I could posit to you that if we didn't have the civil rights law, something awful might have happened that would have changed the view that everyone has of civil rights in general. And on that alternate version of Earth, we aren't having this conversation because of how harmonious we are living together. I base that on the general reaction that we saw in the American populace when armed guards had to escort African American kids into school, or when the police turned water hydrants on other citizens. And I generally believe in the good and moral nature of the American people. It's also possible that it's the 1970s and a violence-ridden hellhole. We just don't know. I know some of you think this is a potential ill versus the actual evil. As some of you may know, a pornographic film star named August Ames recently made a lot of waves by refusing to do a scene with an actor who also starred in gay porno films. She did so because she did not want to have sex with a person who also did gay porn and may have engaged in other homosexual relationships outside of his dealings as a porn star. She viewed, rightly or wrongly, it as a matter of personal safety. Others viewed it differently, responding with such well-seasoned arguments as, "The world is waiting for your apology or for you to swallow a cyanide pill." I would have been very interested to see some litigation here. Hey lady, you have a duty to fuck this guy. The clash of prescriptivist virtue signaling and feminist ideology would have been entertaining for days, months, or maybe even years. Sadly, it appears that the virtuous people on the internet convinced this porn star to kill herself instead. But wait, this really isn't the perfect example of this sort of thing to happen, because pornography, unless I'm mistaken, is not a public business. But what might be considered a public business is prostitution, because it is legal in at least one state. You can imagine, dude walks up to a lady, establishes that she's a hooker, and is like, "Eee," all Fonz-like, and probably a little creepier than that, but she's like, "I don't fuck," boop, insert whatever pejorative, whatever race, religion, whatever you like. He's like, "That's discrimination," and that goes to court. And now we see who wants to tell a woman who she has to have sex with. That would be a good time. Personally, I'm willing to accept the idea that civil rights legislation might have been necessary, but I have a very difficult time rationalizing how this is supposed to fit into a free and liberal society. Eventually, you would just sort of assume that we'd advanced far beyond this sort of thinking, and that they would no longer be needed. In any case, it is pretty obvious at this point that I don't think the government has a particularly compelling argument for dictating wedding cake policy or promoting the posthumous lynching of Martin Luther King. I don't think that either of them really advance the cause they are purported to. I view this whole scenario as a clash of good intentions that hope that we would all have the freedom to live our lives as we choose, not burdened by the state to create certain associations, to do certain things, and to say what it thinks right for us to say, but also that we would be living next to good, moral, righteous people and that we would never need to fear that they would mistreat us for who we are. And I know I come down on the side of liberty rather than the side of morality here, because history has taught us that morality, being our guide, has led to terrible atrocities. See the Soviet Union and everything that Midget Radio has ever said. That's what I think, and hopefully you'll join me, if not now, then someday. In the last minute of this video, I'd like to make an address to my fellow creative types. My suggestion to all of you out there in the creative community is never tell people what you are thinking. This is a clear-cut case of thought crime. Whenever people would proposition me for a commission, I would ask them to describe the project, the requirements, the timeline, and what they were willing to pay. I would tell them one of two things: I'm interested or I'm not interested. Now, this wasn't particularly to get around anti-discrimination laws, but it would be pretty hard for anyone to establish that you were interested or not interested specifically or primarily based on a particular protected preference. If they ask you to elaborate, you can tell them that it just doesn't catch your fancy. Done. Chances are you'll never run into any issues like this. But when you see stupid shit like this, you know it's the right thing. Don't tell people what you're thinking. Preserve the freedom of your own thoughts. Anyway, take care. Signing off. This has been TacticAngel. Have a good one.